Hi there. Victim of domestic violence, a victim of domestic violence is not always a victim. Sometimes the alleged perpetrator is victim of non molestation order or occupation order. This is because the applicant convinced the court based on the false allegation and accordingly court make an order based on false allegation, and the perpetrator, the alleged perpetrator, is actually became a victim. In that video, I'll give you some information how to defend the non-molestation order if it is based on false allegation, or how to set aside the non-molestation order. Set aside application is required if you fail to attend the return date to the court. In that case, you can make an application, or if you subsequently want to discharge the application very extent, or if you want to discharge or set aside, you can make this application. So this is very basic application form. You need to fill up your name, the applicant name, date of court order, and the reason for applying, and you need to write the applicant or respondent address, sign and date. In addition to that, you need to make an application for you need to provide a witness statement. But let me deal with first how to defend the case. Now, normally you'll receive the court order if it is most of the cases ex parte basis without notice, because the applicant convinced the court that if you know this application, you could dangerous or risk for her or for him. That's why the court would been made without notice, and then there will be a return date after 2 weeks normally, generally, yeah. So you should return on that day. Now, at that point, it's very important. Couple of things. First, you should comply with the court order, and then secondly, you need to prepare yourself to defend the case on the return date. To defend the case, you need to read very carefully the witness statement or the allegation made against you, and you need to prepare a witness statement to defend the allegation or to deal with the applicant witness statement. You need to, if it is the case, deny all the false allegation and give us explanation. You need to, in your witness statement, you need to deal with paragraph by paragraph of applicant witness statement, allegation by allegation of witness statement. You need to deny the false allegation and why you deny, how what is the actual fact is you need to put forward. Once you deal with the applicant witness statement and allegation, then it is your time to put forward your allegation against the applicant. So in the witness statement, you need to make the allegation against the applicant. What is that? How it happened, when it happened, which day it happened, who saw it, whether it's reported to the police, whether you raise it to your GP. That's what everything you need to put forward. So witness statement is very important. Most of the cases, also although it is very important for uh, the perpetrator or for the respondent to seek legal advice, but sometimes it is not possible, lack of financial difficulty, because the applicant will get legal aid, so it is easier for her, but respondent sometimes doesn't, so you might not able to pay the fees. In that case, you need to prepare this witness statement by yourself. So therefore, what you need to do, you need to, once you prepare the witness statement, you need to send it to the court by email, and you can send a copy to the other party as well. Attend the hearing, and in the hearing, if you can convince the court with your witness statement that the allegation which was made against you was false, then the court will discharge the non molestation or occupation order. Alternatively, if some allegation which was made against you is true, then you can give an undertaking to the court, which is a promise that that will not happen again, and the court will discharge the set aside the order. If you have an allegation against the applicant, you can ask the court for a cross undertaking as well. That will maintain a balance between you and the applicant. Third option, if you believe, because you know that the allegation was, or the allegation made by the applicant is true or are true, then the third option is you can invite the court that the court will maintain the court order that will give in protection, but you will not admit the fact. There is no admission of the allegation or fact, but court will keep the order. That will give an option for the protection for the victim. At the same time, it will put in a good position that you didn't agree with the allegation what is made by the applicant. And in future, when you will have money or when you will have opportunity to speak a lawyer, when you can hire a lawyer, you can make an application to discharge the court order. So this is what you need to do. And now, as I said about how to defend, and I also discuss how to set aside. Set aside is required basically if you fail to return on the return date to the court, then court will make the final, the domestic violence order, the non molestation order. In that case, subsequently, if you want to discharge the court order, then you need to fill up this form. And in this form, as I said, how to fill up everything, and you need to attach or enclose a witness statement, same as what I just discussed, that in the witness statement you need to deal with her allegation, deny the false allegation, and give an explanation, and then you need to put forward your case. You need to make the allegation against the applicant. You need to give a refer to the supporting evidence such as police report, and then you can send it to the court by email or by post. Court will send you a date listed for the next hearing. You'll attend the court. Sometime again, the court will deal the same day. Maybe you will give an undertaking. The opponent will give an undertaking or no admission of fact, or court will discharge the whole non-molestation order. If this matter is complex and the court find it is not possible in absence of any police report or GP record or any further evidence, such case court will adjourn the hearing and list it for next hearing. In the meantime, court will order police to discharge police report. Probably GP record will be released as well according to the court order. Court will order in any other party to attend at the hearing to give evidence, and court will order probably the applicant or the respondent to prepare the court bundle. This is all stuff need to be prepared for the next hearing, and the next hearing will be cross-examine both party by the lawyer. If you don't have a lawyer, court will ask you question, and you need to be prepared to give answer, and court will make final order on that day. If the children involved, sometimes court list for fact-finding hearing. Fact-finding hearing is quite complex, and sometimes it takes quite a long time, sometimes 2-3 days as well, and examination, re-examination all take place in the fact-finding hearing. Sometimes local authority also involved. So this is the way you can defend the non-molestation order or make an application to discharge the order by filling this application FL 403 with a supporting witness statement. Thank you very much. This is for today.